This morning, I will cover the topic of judicial governance in 5 different perspectives. 1, from the point of view of budget management. 2, from the court administration. 3, the management of the judiciary. 4, through our interactions with the legal profession. And finally, through our very limited interactions with the executive. I start first with budget management. This is an aspect which may not be immediately apparent as to how it will have a bearing on judicial governance. But in my view, it is extremely important.
He's written 8 textbooks, including on criminal law, practice and procedure, sentencing, statutory interpretation and evidence. These books have provided guidance to the judges, magistrates and all members of the Papua New Guinea legal profession in carrying out their functions. Throughout his time in office, which he'll forgive me for saying occasionally was turbulent, Sir Salomo has fought constantly for the maintenance of the rule of law and the independence of the judiciary. We are grateful he has agreed to speak to us today.
There are different kinds of cases that lawyers obviously engage in, but there's a particular class or type of case that I have in mind when I'm saying this, and that is the cases that are politically charged that end up in the courts when they shouldn't be ending up in the courts if those disputes are resolved within the dispute resolution mechanism that already exists outside of the court. But there's a tendency in many jurisdictions for the court to be used as a first and the last resort to bring politically charged cases into the courtroom. And these are the kind of cases that lawyers individually and collectively can make a decision and take a stand and say to clients who insist on their case being presented in the court when there is no real case at hand for judicial determination. For the lawyer to say, no, I can't help you. If you want to argue this case, go and argue the case yourself. If you want to make an application to recuse the judge, you go and do it yourself. I'm not going to do it. And a lot of trouble can be saved if lawyers take that position within the Lawasia region.
Cases. However, we have been able to identify a few causes. For example, in the district courts, the appointment of judges is done by the state government and by the High Court. Unfortunately, there is not much coordination between the High Court and the state government, with the result that we have a very large number of vacancies, 25% as I mentioned. The procedure is that the High Court would select the judges at the district level through an examination and make a recommendation to the state government to make the appointment. And sometimes the state government, as the Chief Justice put it, sits over the files and does not make the appointment. At the High Court level, we have, like I said, about 45% of the vacancies. These appointments at the High Court level are made through a collegium of judges from the Supreme Court. I will come to that a little later because that would really be about the independence of the judiciary.
The advantage of federalism is, of course, it stimulates innovation. One jurisdiction adopts a particular model and other jurisdictions are able to examine that model and see if there are worthwhile features to it. What we have in Australia are essentially 4 models for the administration of courts. The first is the model adopted amongst other things in New South Wales, of which Tom Bathurst is Chief Justice, and it is the traditional model in which the executive effectively controls the administration of the courts, a government department, the Department of the Attorney General or the Department of Justice, providing administrative support to the judiciary, and the judiciary having little formal control over the administrative staff that serve the court. So in the Australian jurisdictions, 4 of them adopt that model.
Now, in Singapore, the budget, once approved by Parliament, is allocated directly to the individual ministries and to independent organs of state, of which the Supreme Court is one. The model we adopt in Singapore is what we call the block budget system. And I think I should explain to you some of the essential features of the block budget system and how that system has a bearing on judicial governance. As the word suggests, block budget approves the budgets in block periods. In Singapore, the budget is approved every 5 years. So this model provides both certainty and flexibility and allows the court to be able to plan in the medium term instead of planning on a year-to-year basis. It provides certainty because you can plan ahead, knowing that your budget has been approved in advance, and it provides flexibility because you can make the adjustments depending on the programs which are relevant for each year. And I mean, in short, you don't have to spend your budget equally over the 5 years. You can vary it, you can adjust it, depending on the project which you implement. And as a result of this essential feature, the Supreme Court of Singapore is able to chart its own direction, make its own decisions as to how that budget is to be spent.
As we all know, constitutions are meant to be social, meant to be a social contract. So essential to the idea of a contract is the idea of the meeting of the minds. Now, if you look at history, and when we look at written constitutions, we look at Western democracies, we have a history in which the people were essentially on the streets demanding for better government. But the actual constitution-making process, the drafting of it, its approval, working out the technicalities, etc., was left to the elite. But as time passes by, the idea of democracy changes radically. And the people are not merely voices on the street, but they claim a greater role in constitution making. So people initially were playing a peripheral role, but today they are expected to play a central role. So from elite working out of a document, we now talk of a more popular participatory process in constitution making. Now, why do we say this?
The ability to possess and to implement the administrative affairs of a state is simply described as the power. In a democratic framework of a constitution, the power is within the people. That is, the people delegate the powers to the rulers, which comes basically in 3 areas: administrative power, voting powers, and basic rights to be included in a constitution. When it comes to devolution of power, it has to be considered under different subjects. I have given here some of the areas: the nature of the state, nature of the parliament or the legislature, tiers of government, main units of devolution, provincial or regional devolution, structure of provincial or regional executive. The lawmaking process, powers of the head of provincial executive, distribution of powers between the center and the province or the periphery, the local government decentralization, the subject of finance, and center-periphery dispute resolution. We'll have to add the devolution of the judicial power too as a topic to this area. The decentralization of power means the assignment of some powers vested in the central government upon regional or provincial units in certain territories that can be said as the devolution on states.
Many ways, basic law is very unique because in this piece of document, this defines the relationship between the Hong Kong Special Administrative Region and the Central People's Government. It also sets out and defines the powers and the system of the government in Hong Kong, its legislature and its judiciary, as well as the rights and freedoms of the Hong Kong residents. And this basic law, although it exists in the form of 3 different formats, if you like, one is that it is in fact a product of negotiation between China and Britain over the future of Hong Kong back before 1997, when negotiations started in the 80s. In 1984, there was a joint declaration signed between the 2 governments. This was signed in 1984 when the 2 governments signed a joint declaration. This joint declaration in the international law arena has the effect of an international treaty. And in this joint declaration, the basic policies of how People's Republic of China will rule Hong Kong was set out in that joint declaration. And there, it also stipulated that China will promulgate a law called the Basic Law to actually give effect to the basic policies that PRC agreed with UK under the joint declaration. So first of all, it is a product of an international treaty. Second, it is also a